Good afternoon, everyone, and welcome to today's webinar. This is the last in our spring webinar series on your legal questions answered. And today we'll be tackling the topic of privacy issues at work. To be joining us for the first webinar, my name is Jessica Steingard, and I'm staff lawyer here at the Centre for Public Legal Education, Alberta, and I'll be facilitating today's conversation. You may also see a CPLEA logo on your screen. Behind the scenes is Natalie Tremblay, our Educational Design and Evaluation Specialist. She will be monitoring the chat during the presentation. She'll be posting a few helpful links in there. So as we discuss today, you'll see some things pop up, so make sure you check out some of those links. And of course, we do have a presenter, and I'm going to leave my introduction of Jacob till in just a few minutes, but you do see another face on your screen as well. Before we move on, I'd like to acknowledge the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those persons with whom we share this great land today. So I'm in Edmonton in Treaty 6, but we know that people are joining us from far and wide today. So this wouldn't be a legal presentation if we didn't have a disclaimer. So just to note that today's presentation contains legal information and is not intended to be legal advice. We'd also like to acknowledge the various generous funding provided by the Alberta Law Foundation and the Department of Justice Canada. Without that funding, we would not be able to do presentations like this one. A few other housekeeping items. We will be posting the webinar recording on our YouTube channel. So we'll have that up in probably a few days' time, so you can check back on it then if you missed something. We also will leave time at the end for questions. So throughout the presentation, you're welcome to type your answers, or your questions. We'll deal with the answers. You're welcome to type your questions into the Q&A box on your screen, but we will save those until the end, and we do anticipate having about 15 minutes to get to those. And when you leave today's presentation, you'll be prompted to complete a really short survey when you exit. We really appreciate you taking just 30 seconds to answer those questions for us and let us know what you thought of today's presentation. So who are we? So if you've joining us for the first time and haven't heard of the Centre for Public Legal Education Alberta, a mouthful, so we use CPLEA for short. Our mission is quite simple, and that is to make the law understandable for Albertans. So we are a nonprofit organization. We serve all of Alberta. We provide legal information and education through our various booklets, tip sheets, videos, webinars like this one, websites, FAQs, and more. And everything is free that we produce. And our goal is to make the law available and understandable so that Albertans are empowered to use it when they need it. This is our homepage. So this is cplea.ca, and you can see there the breadth of legal topics that we cover, and you can find information on. I'd like to point out in the bottom center, you'll see a box that says work. So as we're talking about privacy issues at work today, just know that we have lots of other resources available about employment topics as well. And again, that's at CPLEA.ca. Okay, and now the time has come for me to introduce our panelists. So this is Jacob Schweda. Jacob is a volunteer lawyer with the Edmonton Community Legal Centre, or ECLC. Some of you may be familiar with that. He's also a labor relations officer for a large public sector union. Prior to his union work, he practiced labor and employment law in a boutique worker-side firm in Edmonton. He studied law at McGill University and completed his Master's of Law in Labor Relations and Employment Law through Osgoode Hall in Toronto. So welcome, Jacob.
Thanks, Jessica. Good to be here with you today.
Okay, well, we'll just dive into the questions then. We'll get started with question one. So we'll talking about privacy issues at work. Probably the first question, foundational question. What are privacy laws in Alberta?
Yes, good question. And like many legal areas, unfortunately, the answer is not straightforward or simple. So there's a patchwork of different laws that protect Albertans' privacies and that regulate how privacy should be handled in general and in the workplace. Many people, when they think of privacy, will think of the Charter of Rights and Freedoms. That has a limited role to play in privacy rights. because it only really applies to government or public sector actors. So most workplaces in Alberta, most people don't work for the government. The charter will have kind of limited application in those workplaces. The main laws that will protect privacy in Alberta, there's two. One is for folks who work for public sector employers in the provincial realm. So that could be a thing like a hospital or a school board or the provincial government itself. The law there is the Freedom of Information and Protection of Privacy Act, sometimes called the FOIP Act for short. And then folks who work in any other kind of setting will be covered generally by the Personal Information Protection Act, also known as PIPA. We like our acronyms in the legal world. That applies to almost all organizations in Alberta. And then there's a kind of a narrow group of people in Alberta who also will be subject to and protected by a federal law called PIPEDA, which again is a Personal Information Protection Act, but only applies in very specific federal realms like banks or interprovincial shipping, the post office. So the two primary laws that people will be dealing with for most Albertans is going to be PIPA, the Personal Information Protection Act, and FOIP, the Freedom of Information and Protection Act. And folks, of course, might also have privacy rights under a collective agreement if they're unionized in their workplace. And then also the common law, which is a general body of law that judges have made over hundreds of years, has a small role to play in protecting privacy, but it's still a relatively limited role in Alberta.
Excellent. Okay, so now we've got the foundations. We know the laws are. Next question is, what privacy rights do employees have at work?
Yes, I wish again that there was one document that we could direct folks to tell them kind of what their rights are. Again, the answer is that there's a patchwork, and it really depends on your workplace. It depends on whether you're unionized or not. But in terms of all Albertans in the general normal workplace in the province, the rights that they have can be described more as procedural or transparency rights. So, for example, people generally have a right to be told when their personal information is being collected, what it's being used for, who it's being disclosed to. They have a right to access that personal information, to get a copy of it in most cases, and to correct it if it looks like the personal information has been inaccurately recorded by an employer, for example. In general terms, people also have a right to have their personal information collected only for a legal purpose. We're talking about the workplace. So in general, the most important purpose, which I think we'll get into in more detail, is gathering information for the purpose of administering an employment relationship. So you can imagine that an employer has to gather certain kinds of information in order to hire someone, manage them in the workplace, deal with someone who is terminated or who quits. So the law really talks about keeping the collection of personal information tied to that purpose. Otherwise, it's really context specific. So if you have a collective agreement, for example, you might have specific privacy rights laid out. But for most non-unionized Albertans, the rights that they have are really to understand what's being done with their personal information and to only have to give up that personal information when it's tied to a purpose that is legitimate and reasonable, like managing the workplace relationship.
Yeah, I appreciate that's a bit of a loaded question, but hopefully we can tease out some more of those rights through some of these other more specific questions as well.
Yeah.
Okay, so we looked at from the employee side, and you've kind of touched on this a little bit already, but what personal information can an employer collect?
Yeah, so this again is going to be tied back to having to have a purpose, a lawful purpose. And the language that's used, for example, in the Personal Information Protection Act, which is the one that most Albertans in their workplace are going to be relying on, is that the employer can collect personal information, which basically means information about an identifiable person. So it's not information in general, it's really information about you or about a coworker. It's really tied to a particular individual. They can collect that information for the languages establishing, managing, or terminating an employment relationship, or a post-work relationship is the language that the legislation uses. But they can only do that to the extent that it's reasonable. These are words that lawyers love to use, and they're not very helpful for kind of the average person who's trying to understand the law. But essentially, it means that the employer cannot go beyond the bounds of reasonableness, cannot go to the extremes when deciding what kind of information that they need. So if we think about, okay, what kind of information might be needed to establish, manage, or terminate an employment relationship, you can see how general that language is. So we think about, okay, you're hiring someone, you're bringing them on board, you're training them, you are supervising them, eventually they might leave, or you might end the relationship as an employer. You need things like their contact information, you need to know their social insurance number, you need to be able to provide enough information to the government when filing their CPP or employment insurance deductions. You probably need information about the person's skills and qualifications. So if it's a job that requires a degree, you need to be able to verify that the person actually has the degree that they say. So you might be looking to collect that kind of information. Or you might be trying to establish whether they are a good fit, whether they have good, positive character. And for that, you might need to gather a reference from a previous employer. So the question, rather than being a list of what can and cannot be collected, the question that's going to be asked by the law is, in this context, to establish or manage or terminate this employment relationship, what is reasonable, what is necessary to carry that out? I think sometimes where the rubber hits the road for people, where they're asked for additional information that can feel pretty intrusive, is when there's a workplace problem. So for example, if you are at work and someone has made a complaint against you, the employer, in order to properly manage the workplace, to make sure that they're responding to concerns that are raised, they, in many cases, need to gather information from you. So they might sit you down for an investigation meeting. They might ask you to provide documents or texts or email messages or other documents that have been created in the workplace in order for them to really do a proper investigation and to carry out their role as an employer. The other place where I think there's sometimes tension is when an employer is trying to determine whether someone qualifies for a leave or for a benefit. Sometimes, for example, if you would like to take parental or maternity leave, the employer might need evidence that you are pregnant or that you're parenting. Examples like that, or you might apply for a benefits package and the employer might need to gather certain kinds of information to see if you're eligible for it, if you can be enrolled in it. So again, it's really tied back to what is the purpose of the request for information? Is it reasonable? If it is reasonable, in many cases, the employer will be entitled to request it or to collect it. I think one of the biggest things to flag is that in the general world of privacy, when people are gathering your personal information, the default is usually that they should be getting it directly from you or gathering it with your consent. The law in Alberta creates a special category for employees. Again, this is PIPA, the Personal Information Protection Act, and it kind of loosens the rules for employers a little bit. So as long as they can tie the collection of personal information to a workplace purpose, they don't actually need your consent to gather it, which is, I think, a surprise to many people. So yeah, I think that's a little bit of the information that they can collect, and we might touch on more specific kinds of information with other questions.
Perfect. And yeah, that was news to me too. So thanks for sharing that a little carve out in the legislation there. Okay, so we've looked at from an employer perspective, what can they ask for? So now looking again, what personal information does an employee have to disclose? The flip side.
Yeah, so there's the theory and there's the practice, the practical parts of this question. So the theory is kind of the flip side of what I said about what an employer is allowed to collect or to request. The flip side is if an employer asks you for something and what they're asking for is reasonably necessary to administer the employment relationship, then the employee, the worker, should disclose it. And if they're directed by the employer to do so and they don't, then there's risk. So I guess one thing on the more practical side to flag is that if you are a non-unionized employee, which is the case for most Albertans, you're always at risk of facing a without cause termination. And essentially what that means is that whenever we're considering how to respond to an employer demand or request or a policy, it's good to keep in the back of your mind that an employer, in many cases, if the relationship goes sour or if they don't like the way that you're handling their requests, they do have the right to terminate the employment relationship without cause. Generally, that would lead to some kind of payment in lieu of notice. So you would have to have warning that it's going to happen in the future or payment in lieu of that warning. But they don't actually have to establish a reason to terminate you. And I think people are often surprised about that. So I bring that up in the privacy context because there are not a lot of strong protections that would jump into place if an employee said, I'm not giving you that personal information, employer. I would always be concerned that the employer would at some point consider whether the relationship is not working out and end the relationship. An important exception to that is if you are unionized. If you are unionized, you have what's called just cause protection. So you generally cannot be terminated unless there is cause. And you also have a union on side that can file a grievance to challenge a request for information from an employer that is seen as unreasonable. You don't have that same kind of process or system in place to hold a non-unionized employer accountable. So to get back to the question, in theory, you should only be required to provide information that is necessary and reasonable for managing the relationship. So if an employer, for example, when you're first onboarding, they say, hey, we really need to know your current address, your residence, because we need to fill out tax documents, and income tax in Canada is generally based on the province where you are a resident. And let's say that it's a remote job and you didn't tell the employer that actually you live in British Columbia, not in Alberta. If you refuse to provide that information, you don't really have good grounds to do that. And you don't really have a good way to challenge the employer on that request. So in short, in theory, if the request is reasonable and it's needed, then you should provide the information.
Perfect. I love the mix of theory and practical. What should happen and what does happen? Yeah.
I'll just jump in with one other piece. I'm sorry, I forgot to mention this. There are certain categories of personal information that have some special protection, I guess is a way to say it, in the law. So for example, another piece of legislation that comes into place in the workplace a lot is the Alberta Human Rights Act. And that is kind of our anti-discrimination statute. And it's often an important law for protecting people in the workplace with a disability or with another form of social adhesion that requires some protection. So for example, if an employer is asking you for things like information about your race or your religion or your sexual orientation or your gender identity or expression, they are allowed to ask about that when you've already been employed, when you've already been hired. But it's very high risk for an employer because they really need to be able to establish, why are you asking this question? If they don't, and they collect that kind of private information from you, and then you suffer a disadvantage at work, it could be the basis for a discrimination complaint to the Alberta Human Rights Commission. And there's even more protection for a person when they're first applying for a job. So in the application process, before you're hired, the employer should, in almost no circumstances, ask you questions about your religion, your sexual orientation, your gender identity, and other protected classes under the Alberta Human Rights Act. So flagging that if you're getting questions about those kinds of personal information, then it is it might be time to chat with someone about what's the purpose of this? Why are you asking me for this information?
Yeah, that's a huge piece of the human rights component and how privacy and human rights kind of intersect in different ways. Okay, let's move on to our next question. We hear a lot of talk about privacy policies. So must an employer have a privacy policy?
Yes, so here again, the short answer is, sorry, there's not a clear short answer for everyone, but for most employees working in a non-unionized workplace in Alberta that's not a bank or the post office or another federal workplace, yes, the Personal Information Protection Act does require that every organization, which would include virtually all employers, that they have a person who's designated as their privacy officer. Also, that they have in place policies and practices to carry out their obligations under the legislation. There's also an entitlement for a person to ask, to require that the organization give you a copy or a written explanation of those. And that would apply to you certainly as an employee. You could ask your organization, your boss, hey, could I see a copy of the privacy policy? Most mid-size and large organizations will have this. Some very small employers are not even aware that they're required to have one. So if you ask the corner store, hey, could you show me a copy of your privacy policy? Technically, they should have one, but many in reality don't. So that's the short answer.
Perfect. Okay. So now that we've kind of laid the groundwork on the privacy policies and the information that we can disclose, there's a few more, I guess, nuanced questions. And some of these were from some of you who registered, had sent these in beforehand. So thank you for sharing those questions. So the first one being, can an employer make rules about employees posting on personal social media accounts? This is a juicy one.
It is a juicy one. It's pretty timely. We all are more exposed online and we're sharing a lot more information online. The short answer, again, is yes. If you are in a non-unionized workplace, the employer does have the ability to set out policies about how folks represent themselves, to try to control risks about what their employees are saying in public. The fact that they're allowed to create that policy, though, doesn't answer the question of what happens if you don't follow it. So that's a separate question. But yes, an employer can have in place a social media posting policy. However, we've been talking about the general principle that when an employer collects personal information, that it has to be tied to a particular workplace purpose. So that kind of cuts both ways. It means that the employer does have a lot of leeway in what they ask for for information of their workers when it's related to the workplace. But it also means that when they don't have a workplace purpose or another kind of pressing purpose, that they should not be collecting personal information without your knowledge and consent. So if you're the average worker in Alberta and you don't have any current complaints against you about what you're saying online, there's really no basis for the employer to be reviewing, keeping copies of, looking at your personal social media. If they can't explain what the workplace purpose is, then reviewing or copying or taking screenshots of your Facebook or your Instagram, in general, that could be seen as an unlawful collection of your personal information. So the law does try to draw that limit around the workplace relationship. Now, if an employer that you're working for receives a complaint from the member of the public or from one of your coworkers who has added you as a contact on social media, and there's reports that you're saying things that are offensive or that you're representing positions of the company as though you speak for the company, all of a sudden that private personal page gets pulled into the workplace, and the employer does have a responsibility to investigate. And so at that stage, they are in a position to go and look at what's available on your public pages. And they could probably, in many cases, even require you to show them copies of things on a closed Facebook group page, for example. If you are in that closed space that you think is private, if you're still using it to harass a coworker or to make offensive or discriminatory comments. There are people often, when they hear this, there's a sense that this is a violation of your freedom of speech or the charter. And if you work for a public employer, then you do have extra protections coming from the charter about freedom of expression. So if you work for a school board, if you work for a hospital, if you work for the government, there are some more complicated considerations that come into play in those situations. You have a bit more leeway about expressing yourself, but most people, again, don't work for a public employer. And again, the charter does not apply if you work for a private company or in the private sector. So as surprising as it is, our law really does give a lot of authority to employers to control and request and require information from their employees. The other nuanced piece I'll just add is that coming back to what I said previously, if an employer has a social media policy and you're refusing to follow it, they always have the option to terminate without cause. So the risk you run, even if you are not technically in breach of the policy, or even if you're compliant with the policy, but kind of avoiding answering questions from the employer, you always have the risk that they're going to end the relationship with notice, but without having to give any kind of particular cause. Yeah, and I think we'll touch on that a little bit on a question about what do you do if your privacy rights are violated. So I'll leave a little bit to that as well.
Thank you for that. That was very comprehensive and spanning some of those different scenarios. So hopefully that gives folks an idea of when and when not to engage in social media, and blurring the lines with work there. Okay, another very nuanced question and a big topic as well is, what medical information does an employee have to share, or can an employer request?
Yeah, a fair question. I mean, medical information is obviously some of the most private information that we have. And it can reveal things about us that are, as I said before, protected by other pieces of legislation. Obviously, your medical records could, for example, reveal if you're pregnant or if you have a disability. So it's always a very tricky area for employers and employees. People might get tired of hearing me say this, but we're going back to the first principle of, is this information necessary for the employer to hire, manage, or terminate the employment relationship? That should really guide what an employer is asking for, how much they're asking for it, how much detail they're asking, and what an employee provides. So for example, if your job requires you to operate heavy machinery, it might be that the employer is entitled to ask for confirmation that you are physically capable of actually operating the machinery. Or if the job is very physically intensive or very safety sensitive, they might be entitled to ask for confirmation that you are healthy enough or that you have the physical capacities to do the job. This kind of has become a contentious issue with respect to vaccines. But you can imagine that in some workplaces where it's relevant to the health of a patient, or where there's an outbreak of a certain kind of disease, like a flu, for example, a flu epidemic happening on a long-term care center, for example, it could very well be appropriate and lawful for an employer to ask you what your vaccination status is, to determine whether they have to put in place safety guards or other measures to keep you and your coworkers and the public safe. So that's, I think, another example of where medical information could be legitimately requested. I think the place where it most often is legitimate is when an employee has a disability, could be physical or mental, and they are asking for an accommodation in the workplace. As part of that process, an employer needs to be able to determine, first of all, to confirm that you do in fact have a disability of some kind that requires accommodation. And then also they need to be able to understand, what are your limitations? So what, from a medical perspective, can you not do in the workplace that might require them to change the conditions in the workplace to help facilitate you coming back and being successful at work? So it's very rare, for example, that an employer would be entitled to a diagnosis. They don't really need to know what exactly the doctor has said that you have. but they do generally have a right to receive information about what your limitations are. So for example, it might be that you have some kind of degenerative disease. You're not required to necessarily provide the diagnosis, but you might be required to say that you can only stand for a certain number of hours, that you can only sit for a certain number of hours, that you require a sit-stand desk, that you require breaks. That kind of practical functional information is generally what would be shared. And occasionally, if an employer is trying to decide whether the employment relationship is going to continue, they might need information about a prognosis. So they might need to know, what are the chances that you're going to get better in the future? And the other time when it comes up quite frequently is if an employer is trying to facilitate you getting benefits. So for example, if you have a disability benefit plan, you might be required to provide information either to the insurance company or to the employer, depending on the plan and the setup that they have, to confirm that you meet the minimum qualifications for that benefit. So yeah, hopefully that's helpful.
Yeah, absolutely. Thanks for covering all those kind of different scenarios and instances where medical information would be needed, and like you said, to what extent or how much information the employee needs to provide. Okay, we have our next question here. So again, another nuanced topic. Does an employee have a right to privacy on phones that they use for work?
Yeah, so again, giving that old line that lawyers love to give, the answer is it depends. And people, as they hear this, they probably can start thinking of different scenarios. The law and the courts, including the Supreme Court of Canada, have recognized that our phones contain an enormous amount of information about us, and that there are lots of privacy risks involved with sharing what's on the phone. And there are restrictions, for example, on how police can access telephones. But in the workplace, again, the question is going to be, what is the purpose of gathering the information from the phone? There's a kind of multi-step, multi-factored exercise that's done by the privacy commissioner and different people who look at these cases, but they're going to want to consider things like, okay, why is the employer asking for the information on the phone? Who owns the phone? What kind of policies are in place in the workplace that talk about what's private and what's not on the phone? So you can imagine if everything's going well at work, everything's normal, no complaints about you, and the employer, because you have a nosy supervisor, wants to look at your work phone and check your personal email you're also sending from that phone, you're allowed to also use it for personal use. That's probably not going to be a legitimate collection of your information or review of the phone. But let's say that the employer has received information that you are using your workplace phone to run an elaborate fraud scheme, and you are sending emails about the fraud and you're calling people about the fraud. Or you can imagine many other kind of unlawful activities. The employer then has a legitimate expectation to be able to investigate that. And if they're smart, the employer will have in place a policy that reduces your expectation of privacy in that phone. So they might have a policy that says, the phone belongs to us. You don't have an expectation of privacy, and we will investigate and access the files if we receive a complaint. If they did that and then followed up in a reasonable way, let you know what was going on and why they were doing it, they would have much stronger grounds to actually look at the phone or require you to show it to them than in the first example that I gave.
Yeah, it is our favorite answer. Hey, it depends, or it's not as simple as it seems. But hopefully, for myself, I know at least that provides a little bit of clarity. So hopefully, those who are wondering about this also, there's some clarity there around some boundaries, but also like you talked about those purposes. Why are we? What is the purpose here? Okay, those are our formal questions, but I do have a couple more, as I had mentioned earlier, I might post to you. So I'm going to move on to the next screen, and I do know at least one question in the chat or in the Q&A as well. So if you have questions, you're welcome to pop them in there. But I have two more follow-up questions for Jacob before I move over to that question. So first question, and we kind of touched on it a little bit, is what can employees do if they believe their privacy has been breached?
Yes, good question. So, in the law, we like to talk about people's rights and what the rules are, and sometimes we forget to talk about what happens if those rights or those rules are broken or violated. The short answer is if you're unionized, your union, they have a good system in place to file a grievance, and an arbitrator does, which is where a grievance can eventually wind up. An arbitrator does have the legal ability to enforce privacy laws. So, for example, there was a published case from a number of years ago where one department of the government of Alberta ran credit checks on their employees without getting permission from the employees and without having a workplace purpose, as we've talked about. And an arbitrator eventually awarded damages to each employee, I believe in around $1,200, if I remember correctly, per person. So if you're unionized, the union is going to be the best resource to help you enforce your privacy rights. If you're not unionized, unfortunately, the answer is not as quick, not as easy, but we do have a body in Alberta called the Office of the Information and Privacy Commissioner, which has been put into the chat there, the link to their office. There's also a federal privacy commissioner if you happen to be the very small number of Albertans whose workplaces are governed by federal law. And you can file a complaint with the Office of the Information and Privacy Commissioner, and basically you'll explain why you think your privacy rights were violated, what parts of the Personal Information Protection Act or the FOIP Act for public bodies, which part of the act has been violated. The commission, the privacy commissioner or her delegate, they will investigate, they will try to mediate to see if there's a way to resolve the concern. And they do have the ability, if that fails, to issue a formal report that says whether or not your privacy rights have been violated. A couple of challenges with that. The first one is speed. I think the last time I looked at their annual reports, their timelines are something like 18 months to get to a mediation process. And then I think probably a year or two beyond that in some cases to get to a formal inquiry. So you'll find that you might put in an application and it might sit and wait for a year before you hear anything. The other weakness, I guess, main weakness with that process is that the privacy commissioner does not have the ability to award damages. They can't order the employer to pay you money, and they also cannot fine the employer. And a lot of people think, well, what's the point then? Why am I going to go through all this to get a report? And that's fair. There is a part of the Personal Information Protection Act that says that if you get this report from the privacy commissioner that says that you have had your privacy rights breached, you then have the right to sue the employer in court for damages, for money. The last time I reviewed the case law on people suing for money after getting a report from the privacy commissioner, there were exactly 0 cases of a worker doing that. So that tells you how long, stressful the process is. And also, as you saw from my example with the credit checks, the damages that you might be receiving are very low in comparison with other areas of the law. Most people don't want to spend years of their lives and all of this energy and time to potentially get a couple $1,000s down the line. If you have real damages, like someone's violated your privacy and you have experienced actual quantifiable financial damages, then it might be worth it to go down that path. But for most people, it's really not worth it. However, that is the main way to enforce your privacy rights, through a grievance if you're unionized, through the privacy commissioner's office if you're not. And there are a number of very narrow exceptions where you can kind of skip the privacy commissioner and you could consider suing your employer in court directly for damages, for money. But they are very limited, as I said. You'd want to talk to a lawyer about it beforehand. And there are things like if your employer somehow collects intimate images of you, so nude images of you, and then discloses them. That's a special category where you can sue directly. and other very narrow exceptions. But typically the example would be the Privacy Commissioner's Office would be your remedy.
Excellent. Thank you very much for that. One final question before we move to the question from the audience. How can employers and employees better deal with stigmas about mental health in the workplace? So connected to privacy in the sense of, medical information there.
Yeah, I think from an organizational perspective, the best thing would be to have very clear policies in place that acknowledge the importance of mental wellness, mental health, and that set out clearly for everyone, workers and bosses and supervisors, for everyone involved. What do we do when there's a potential mental health concern? How do we gather information? How do we keep it private? The policies should clearly state that people should feel supported, that there's no stigma involved. So there is a policy answer that should be in place, absolutely, so everyone knows. But I think the more important is that supervisors and executive officers and managers and leaders in the workplace should feel free to talk openly about concerns or challenges related to mental health, not necessarily giving specific examples, obviously not of their people supervised, but they could talk about how important it is to take your sick days if you need a mental health day. That's a legitimate reason for you to be accessing that. And people are, we're talking about privacy and what an employer can gather and require you to give, but the law doesn't stop you as an individual from also revealing things voluntarily. So if there's a manager, it might be very powerful for that manager to say, I've experienced mental health challenges in the past, and here's how I responded, and that's why I recognize how it's important. So no one should ever feel obliged to share, but if there's a safe, comfortable place where leaders and senior managers are open about the issue, I think that's probably the best way to reduce stigma.
Yeah, that's a great response. Really, those, the law can say one thing, but it's those soft skills and those, relationships that also matter as well.
Yeah, absolutely.
Okay, we have one question in the chat. So, can an employer make rules about the employee not working in another place without consent, even if that other job is not related to your job or interfere or in conflict of interest? So I'm guessing in the context of working two jobs, potentially, is how I'm reading this, I think.
Yeah, fair question. I think you're going to get the standard answer. It depends. If you are unionized, typically you would have an avenue to challenge that. That I think if it was completely unrelated and didn't interfere with your workplace duties, and there was no conflict of interest, a unionized employee would be able to challenge that rule. They could file a grievance. They could find a way to push back on it. With a non-unionized employee, there's a couple of pieces to it. If you agree to it as part of your employment contract, that you are going to devote your time exclusively to this job, then yes, of course, you've agreed to it. That is, I think, in general, an enforceable term. If you didn't agree to it, or you don't have a written contract and the employer is just putting in the requirement, we're back to what I said before about what happens if you breach an employer policy in a non-unionized workplace. So if there's a clear policy about not being permitted to work in another place on your own time, and you breach the policy, the question is not whether or not the employer can terminate you, it's whether or not you're going to get notice of termination or some pay in lieu. So if an employer has this policy in place and you don't follow it, the employer, or even if you do follow it, the employer can choose to terminate the relationship. And the only thing you're going to be arguing about is whether or not you are entitled to some money or some time, some notice. And I think if there was a carefully crafted policy about this and you knew about it, you were given fair notice of it, and it's enforced consistently, maybe an employer would have grounds to argue that they had just cause to terminate you, which means you get nothing, right? No notice in lieu, no warning. But even if they couldn't prove that they had just cause, they could still choose to let you go without cause. So whether or not the policy, the question is not so much, is the policy allowed? An employer can publish whatever policy they want. The question is, what happens if people don't follow it? And because you're not unionized, you're at risk whenever you don't. You're at risk in general, but you're at risk if you don't follow an employer policy. So.
Excellent, thank you.
Yeah.
Well, I don't have the questions in there. I'll give it kind of a few more minutes. I can do a few things, and if there happens to be another question before we head out, then we can take a look at it. But thank you, Jacob, for all those responses. I know I learned a lot, and I'm hoping everyone who joined us did as well. Just a reminder that we have a lot of information available for free, like I said, on our website as well, cplea.ca, including lots about work. And this webinar will also be available through there as well. There you'll see on the work, if you go to the work page, there's a little button you'll see about privacy. And this webinar recording will be available on there as well going forward. So make sure you check that out. And again, just to highlight some of the sessions that we've done previously in this series. So we talked about owning property with someone else, harassment at work, dying without a will, and getting a grant to probate. So a mix of kind of wills and estates and employment topics there. And again, those are all available on our YouTube channel for you to watch anytime. We don't have any more webinars scheduled going forward, but we will pick up again in the fall after everyone's kind of had a summer break. So watch for more webinars coming in the fall. And again, thank you all for joining us. Thank you, Jacob, for joining and sharing all of your information there with us. And as you leave today, please fill out the really short evaluation form we have so we can know how we did today and if there's any other topics that you would be interested in learning more about. So I don't see any other questions in the Q&A, so I think we'll leave it there unless you have any last parting words, Jacob, to add.
Just thank you to everyone for your interest in this topic, and I'm sorry that there are improvements that could be made to our privacy protections in Alberta. So thanks for your interest in the topic, and yeah, hopefully you take the time to learn more through CPLEA or through the Office of the Information Privacy Commissioner. They have some good cheat sheets on their website, some good explanatory documents too, if people want to learn more. So thank you.
Absolutely, thank you. Well, we'll wrap up there. Thank you everyone for joining us, and have a great rest of your Tuesday afternoon.